Okay, good morning and welcome everybody to the Vocational Science of Freedom online law class for December 13th, 2020. And this law class will be on the Vocational Science of Freedom Status Doc set. The download link for all of the handouts today are on Mega, and if you've joined the Vocational Science of Freedom Gilded server, you can find that link in the Gilded server in the chat room for the class. It will also be posted in the YouTube page for the class in the links and description underneath the YouTube upload. And so for today, we'll start with the outline for the class, and I'll cover everything that we're going to go over in the class as far as the subjects are concerned, and then we'll get into the first handout, which will be the Edward Mandel House quote. And just for those who may not be used to how I color code things, the papers of the Vocational Science of Freedom, things in red basically means pay attention. Things in light blue means pay more attention. The dark blue will be the categories, and the purple is my own notes on various different things. And then when it comes to PDF documents, I'll either have things outlined or I'll have a sticky note on the PDF where I have a note specifically about something in one of the PDFs. So the PDFs will be the only things that won't be color coded, because obviously PDF runs on a different kind of system than Word. But so with that, what we're going to be covering today is, first we'll start off and I'll cover the understanding of what the law merchant system is. And there'll be various different handouts that I'll give out. So we'll cover exactly what the law merchant system is, how it was developed, how it's a foreign system of law created in medieval times, and that we're still dealing with this same system, this law merchant system, and Roman civil law in America, and that it's a foreign system of law, which we'll get into at the end. So we'll cover the law merchant system, I'll explain that, and then we'll get into the status doc set for the Vocational Science of Freedom, what it does, why we created these documents, why I've been working on them literally for over 25 years, and what the presumptions that they rebut as far as when you file them onto the public record to correct the presumptions that the law merchant system puts you under. And we'll cover each handbill for the status docs, at least all the handbills that are done. There are some few handbills that are not yet finished for some of the status docs, but you'd still fill them out in exactly the same way as you'd fill out the rest of them. So the description and the understanding of how to fill them out is pretty much the same. It's taking the information that's in red and filling it out. Now, if you have the Vocational Science of Freedom do it, if we do it for you, you don't have to worry about any of that. So if you want us to do your status doc set, it's 21 rounds of silver, meaning a trade round, which is the actual definition of a dollar, which is 1 ounce of 99.99% silver, and under the Banking Act, a Spanish milled dollar is what is considered to be, and by the definition, an actual dollar, not a Federal Reserve note. And so if you want us to do your doc set, it's $21, and it has to be 21, and I can't make it any less than that, or I would, because the federal Constitution clearly states that anything over $20 is in the common law. So we always want to stay within the common law. We want to have our transactions also be under the common law always, and so that's why we do 21 rounds. And so we'll get into each of the status docs, what they do, and why you should do them, and the order of which they should be filed, and why we need to get them done. And I'll give I'll give the outline also of the April class, even though we won't be recovering. We'll be recovering some of the stuff that we talked in April, but the the April class was the rebuttable presumptions, which is also uploaded on YouTube already, and under self-government quadrant. And so we'll cover that, and we'll get into the binding arbitration process, which you can do once you have your doc set done, meaning when you have your full doc set done and you've served them on government entities, on corporations, which of course we are running, being administered, our abandoned estates are being administered through a corporate government, corporate governance. Yes, the republic is still here, but at the same time, it's kind of a republic which nobody occupies, or very few occupy, I should say. And that's another aspect of why it's so important to get the doc set done, so that you are actually occupying your status as one of the people in the constitutional republic, and not being a person under the corporate democracy. So we'll get into the arbitration process, so basically when one of the trustees, which you've appointed, and with the status doc set, which we'll get into later, is that you appoint pretty much everybody on the planet, for the exception of those that are a member of your house, as trustees of your estate. And they only accept that appointment of being a trustee of your estate if they administer an aspect of your estate. So it's an open contract of which they enter into by their own actions, right, which we'll get into later. And then so we'll cover the whole arbitration process and how you file it, whether it be for traffic tickets, foreclosure cases, debt issues, whatnot, and all the rest of these things. So we'll get into that, and I'll cover some of what's actually stated. This is some of the documentation actually pulled from some of the documents. So I'll explain how the trusteeship works, and I'll explain the clock, how you're supposed to file them and serve people, and when they enter into default, and so on and so forth. So that'll be the whole arbitration process. And what you need to know if your estate is named as a defendant in one of their Roman civil law courts. And so we'll cover the basis of what you should do and what you should file, from pleas and abatement to Brady requests to judicial notices, and then we'll cover venue, and I'll cover the easy guide, which is something out of a separate class, not a VSOF class, but a class and set of documents. It's basically an entire course on equity law, how to go to court, how to go to these equity courts, and their system of how they do things. It was written and developed by an attorney out of Florida years ago, but it's really well laid out as far as being able to, if you buy Jurisdictionary, it's a very easy class to follow to understand Roman civil law process, code pleading, if you will, or statute pleading, if you will. Which is not where we want to be at, clearly, in jurisdiction, but the easy guide will show you at least how court cases flow, and I'll show you the difference between how an equity case flows under Roman civil law, again, code pleading or equity pleading, or statute pleading, and the difference between that and a court of record. And then we'll finish up the evening with Q&A. So let's scroll back up here to the top, and let's open up the first handout, which is the Edward Mandell House quote, and I'll cover that. So Edward Mandell House was basically Woodrow Wilson's handler, if you will. Woodrow Wilson was president from 1913 to 1921, and he was a college professor. He was good at writing speeches, and they knew that they compromised him early, as the deep state always do. And he was compromised for the very reason that when he got into office, when they allowed him, or when I should say when they placed him into office, under the agreement that he would sign the Federal Reserve Act. So Edward Mandell House was Woodrow Wilson's handler. He was a Khazarian mob banker agent and had full control over Wilson pretty much at all times. Wilson really didn't do much without House's okay, if you will. So this quote came from House, and it was in a letter to Woodrow Wilson explaining what their system was going to be. Now this is pre-central bank. This is pre-Federal Reserve, right? Because Federal Reserve was signed in 1913 and was created on an island called Jekyll Island. And there's a great book by G. Edward Griffin that you can read called Creature from Jekyll Island, which explains the whole entire history of how the Federal Reserve came into existence in its secrecy. This quote explains what the rest of the totality of their system was going to create and control after they set up their Federal Reserve Bank. Because what they wanted, what the attorney wants, the attorneys out of the City of London, the Bar Association, the global communists, what they want is they want their feudal system back. And they pretty much have it. I mean, they have it in full force and effect in every way, shape, or form you can possibly see it, if indeed you take the time to learn and see it, which is, of course, what these classes are about. So I'll read this quote, and then I'll stop in various different places in the quote, and I'll explain some of this. I won't get into this too lengthy because I do have a radio interview on the Vocational Science of Freedom YouTube page where I go over this quote very extensively. So I'll just cover it here so that we know, for those of you who haven't seen that particular episode, I'll go through this and cover it so that we have a good basis of what they're doing, how they're doing it, and how we have to reverse engineer it. Okay, so very soon, every American will be required to register their biological property, right? That's the birth certificate. That's what the mother does at the foundling hospital. Now, foundling is a lost or abandoned child of unknown parentage. That's what a foundling is. All of the hospitals out here are foundling hospitals. So, when you register their biological property, the mother signed the birth certificate contract, and then the child gets registered. And of course, this is, of course, unknown to the mothers as far as what they enter into. But they have them sign these birth certificate contracts prior to them leaving the hospital. And they get very, very, let's say, agitated. They get very, very agitated if a couple or a mother does not sign one of these things before they leave the hospital because they want their property. Okay? So, very soon every American will be required to register their biological property in a national system designed to keep track of the people, and that will operate under the ancient system of pledging. Okay, now, the ancient system of pledging. A lot of people have argued that everything that's going on is only an aspect of contract, and if we would just remove ourselves from all the contracts, we'd be free, clear, out of the system, so on and so forth. Now, to an extent, they're right. However, there are other things going on which are called pledges. Now, in a contract, you have two people that enter into an agreement of which there is something of lawful consideration exchanged. Say, I exchange gold or silver for a horse, or I exchange someone's skills, say someone to treat that horse, like say a veterinarian, and I say to the veterinarian, I'll trade you your veterinarian skills to come treat my horse, and for that exchange, I'll come, because I'm a carpenter, I'll come, build your shed for you, or something like that. Some aspect of a contract has to have lawful consideration both directions in order for it to be a lawful contract, and that's one of the aspects of contract. Now, a pledge is something different. A pledge is where you give something without having something coming the other direction as far as lawful consideration is concerned. So when you pledge something, you're expected that if you pledge something that you've done it from your own volition, that you understand what you're pledging, and that you are not, sometimes that you're not even asking for anything in return. What what this particular sentence is about is that when it says that that will operate under the ancient system of pledging, it's about the feudal pledge, the idea that you would pledge your allegiance. Sound familiar? You would pledge your allegiance to a lord, and that lord would then protect you. Okay, so, and this is the aspect of pledging their own property, pledging their own children to the corporate government. Okay, so to continue, by such methodology, we can compel people to submit to our agenda, which will affect our security as a chargeback for our fiat paper currency. Okay, so let's break that down for a second, because the aspect of banks and banking and the aspect of chargeback is something that a lot of people might not understand. So, by such methodology, we can compel people to submit to our agenda. Now, what is, they'll get into their, House will get into what his agenda is a little bit later down here, but which will affect our security. The securities that they create are the bonds on the birth certificate. So we know that there's a bond connected to everybody's birth certificate. Furthermore, the birth certificate itself is a security. It's printed on bond paper. It's also a warehouse receipt, because it says this such and such property is so and so. This is the description of the property, such and such, yada yada yada, and this is where it's been registered, right? So when he says will affect our security as a chargeback for our fiat paper currency, they're creating fiat paper currency. They're creating, the credit gets created from us. Without us, all of this credit, all this fiat paper currency doesn't exist. All of the credit comes from our estates. And just to clarify that, the term estate means everything that a man or a woman owns in law. That's your estate. It's not, you do not want to think of the term estate in just a definition of land or a plot of land, which is usually how most people think of the word estate. You want to think of the word of estate as everything that you own in law, which means your rights and your land and your children and your own body. Okay, so affect our chargeback for our fiat paper currency. So when they're creating the credit, or they're using us to create credit, right? They never tell us that it's actually our credit. It's our credit, not theirs. It's ours, which is how this monetary system works, right? So, to continue, every American will be forced to register or suffer not being able to work and earn a living. That's the aspect of the Social Security number. Oh, we can't hire you. You don't have a Social Security number. Well, why do I have to have a contract with the corporate state in order to earn a living, right? Well, that was built into the system. They will be our chattel, right? They will literally be our property, right? They will be our chattel, and we will hold the security interest over them forever. The security interest is the interest that they have in that bond, that we're all bonded debt slaves. And an interesting point of history as far as an indentured servant or indentured servitude, which is something that was quite common during the colonial times. This is what they wanted to continue, but on a massive scale. They wanted everybody to be an indentured servant. Okay? So that's the aspect of the chattel, that will hold the security interest over them forever, meaning that you never come back and claim your estate and claim all this credit. And they're holding that security interest over you because they're still seeing you as an infant, which is the definition of a person. The definition of a person that everybody always or seemingly many people get kind of confused by, is they think that a person, the way that they use the term person in statutes, acts, ordinances, and codes means a corporation. Yes, that's true. A corporation is defined as a person in many different statutes, acts, ordinances, and codes, but that's not the definition that they're using to control you. The definition they're using to control you is Title I of the United States Code, subsection 8, under the definition of person. Which, if somebody wants to put it in chat, that'll be great, because I don't want to kid online right now, but I've gone over it many times in many other classes. But basically, what it says is that every infant member of the species Homo sapien is a person. Okay, infant member. An infant cannot own property. An infant can be an heir to his estate, but until he comes forward and claims his estate, and what was in the medieval times the term was called to sue out his livery. An infant would sue out their livery when they, quote unquote, came of full age. So they would sue out their livery when they came of full age in the Court of Wards and Liveries, which is something you can also look up on Wikipedia. Wikipedia's site or reference for the Court of Wards and Liveries is actually pretty well written and is historically correct. Not that I would ever tell people to go to Wikipedia for law research in general. However, that particular link is not that bad, and does explain what the Court of Wards and Liveries was, how it operated, and what they did there. And thank you. Thank you for the definition, Chief. And in the Court of Wards and Liveries, when someone came of full age, which is how it's written in the Magna Carta, when they came of full age, they'd sue out their livery. Now, who were they suing? They were suing their guardian or their administrator. And now, under this system, which House is explaining here, under this system, the corporate government is your administrator, is your guardian, is basically your daddy, which is the definition of patriotism. Not to anger anyone out there who sees positivity in that word. I don't have a problem with the word itself. It's just I'm just giving you a etymological background of the word patriotism. Patriotism means to call something else your father. Pater, meaning like paterfamilias, that's an aspect of father. So patriotism is to call something else your father. That's why I don't call myself a patriot, and I do not say that I am patriotic to a government, because I don't call something else my father. But that's what they're doing. They're being the guardian of lost and abandoned children, of which have been registered, again, to register their biological property. That's how they've registered them. So your estate is being administered, and they're basically waiting. They're waiting for you to grow up and put a claim down to take it back. That's all they're doing. That's all they can do under law, under the common law. You see, well, we'll get into that later. I'll explain everything else about the aspects and difference between the common law and the civil and Roman civil law later. But just for now, to finish out the quote and to get into the rest of to finish out the rest of this quote, that there is our system of law, of common law, which is still in full force and effect. They can never get rid of it, ever. The question is, are you using it properly or not? That's the question. And also, are you acting as an infant? Are you doing things like registering your biological property in a national system designed to keep track of the people? Are you registering your cars? Are you registering your land? Are you registering your arms? Are you registering your toaster, for God's sakes? I mean, nowadays, every single time that you buy an appliance, you have that little card that says, would you like to register this? No, thank you. Why would I? Because if you register something, you are giving up ownership of it. You're registering the ownership to someone else, and you're saying, here, Daddy, will you please allow me to use this as a usufructuary, which we'll also get into later as well. So, but I just wanted to cover those things so that people understood that aspect of it. Okay, so to get back to this, so they will be our chattel, right, along with everything else that we're registering, and we will hold the security interest over them forever by operation of the law merchant. That's what I'll completely cover the law merchant later today, but that's the point. That's why it's so important to understand what the law merchant is, how it works, and we'll cover that later. Okay, under the scheme of secured transactions. Scheme. He says it right there. He's telling you it's a game. Under the scheme of secured transactions. What is their scheme now? I mean, their scheme now is so ridiculously overbloated that you have things like credit default swaps and mortgage-backed securities and all this other garbage and filth that they pump out of Wall Street, which is nothing but the basis of this sentence. All of it is basically on the basis of this sentence. By operation of the law merchant under the scheme of secured transactions. So, that's everything from the fidelity bond, which is connected to the BC, which we'll also get into today, because doing your doc set includes getting a full audit of your birth certificate bond, which some of the people that are actually in class today have already done, and they will testify to that, I'm sure, if you ask them. And the amounts are large. Okay, we've done this for years now. And how you do it is through a Bloomberg terminal, which we'll get into later. And most of these bonds that are connected with your birth certificate have anywhere from 150 million to 350 million is usually the range of the amount, but I've seen them as high as $500 million. So, yes, so you have bonds connected to your birth certificate. Okay, so that's the secure transactions thing. So to continue, Americans, by unknowingly or unwittingly delivering the bills of lading, that's the birth certificate, to us will be rendered bankrupt and insolvent, forever to remain economic slaves through taxation, secured by their pledges. Again, we get back to pledging. So, delivering bills of lading. A bill of lading is something that's saying, hey, I own this thing, you're warehousing it, right? Now give it back to me. But instead what we do is we deliver the bills of lading to the government and say, oh, we're too stupid to understand what to do with this, so here, Daddy, you take care of it, right? That's part and parcel of the problem, not understanding law. So to continue, so this is, okay, so that's, and by doing that, when he says forever to remain economic slaves through taxation, you are being taxed for the use of your own property as a usufructuary. You do not own it. You're considered to be only using it because the reason is because you have not claimed it. You must make a claim. You must literally stake your claim. And that was, of course, that where we know that term comes from, is when people would go west during the Great Expansion and they would put a stake down into the land, which had a little flag on it, and say, this is mine. They'd stake their claim. Okay. So, without claiming back your estate, you're to forever remain economic slaves through taxation, secured by the pledges, because your mother, at some point, and possibly your father as well, that pledged your existence, your economic value, which is where you get the term human resource. A long time ago, corporation, before the system fully was, that they figured, okay, we've gotten away with this system, this filth for so long, it's never going to revert back to where it was. And of course, the presidents that have signed various different bills regarding the altering of our currency have also stated that we have no intention of going back to how the system used to be, right? But the thing about the pledging is that they're, when the mother and father pledge it over, it creates a trust relationship. And that's the important thing that people need to realize, is that there are all these trust relationships going on all the time that no one's paying attention to because they don't realize what a trust is. And a pledge in this aspect is a form of a trust. Like when you pledge, okay, here's my child, right? So that economic value, that economic worth of you being called a human resource, and now having human resource departments in corporations, they used to just be called personnel, right? I don't know if anybody remembers that or not, but there used to be personnel departments in corporations. No one calls them personnel departments anymore, or very few do. It's now the human resource department, right? Because that's what you are. You're a resource. Your bonds and your birth certificate are a resource on the stock market, right? So to continue, they, us, will be stripped of their rights and given a commercial value designed to make us a profit, and they will be none the wiser, for not one man in a million could ever figure out our plans. And if by accident one or two would figure it out, we have in our arsenal plausible deniability. Because they figured that we could come along and say, well, this is how you're doing this and everything else, and they could say, ha ha ha, you're so crazy. That's such an insane idea. Ha ha ha. Oh, you're nuts. Right? Which is where you get the term conspiracy theory, promulgated by the CIA and the rest of the dark ones, to belittle anyone of a superior mind that could reverse engineer everything that they're doing and saying, no, I see what you're doing, and I'm not going to stand for it, and this is what I'm going to do against it to reverse engineer everything that you have done by law. But just think about that. I'll reread that sentence one more time just to really drill it in as to what is to their hubris, really, is what it gets down to. So they will be stripped of their rights, meaning you don't have any rights, right? A citizen of the United States has no rights. He has privileges. A privilege is something that's granted from government to you, instead of the other way around, where we the people vest power to government, right? So power is always vested to them, but they turn around and grant privileges, which they call civil rights. And the term civil, anytime you see the word civil, as in Roman civil law, that's what it means. Anytime you see the word civil this or civil that, it means Roman civil law. Roman. You ever see the word civil? It means Roman. It's a foreign system of law to us. Foreign. Always has been, always will be. And yes, you're right. You see the brainwashing of what they're doing. That's part of their plausible deniability. So they discredit and they say, you're crazy. And that's when they bring in the pseudoscience of psychology into the courtroom. Right? I mean, I think probably everybody here, and probably a vast majority of people that will be listening, have heard of someone somewhere in some court where they stand upon their substantive rights and say no. What is the first thing that the black robe priest of El sitting up on the bench, which in Latin means bank, what is the first thing that priest does? They turn around and they call for a competency hearing. Say, well, this man seems to be crazy. We're going to have to get a psychologist in here to do an evaluation. Well, you sick fuck. That's just because somebody woke up. So instead of you actually doing what you're supposed to do by law and returning to that man or woman their estate, instead you put them in a psych ward for years and drug them. Because we can't have anybody out here actually telling the truth about what's going on. Because you get enough of these people around, like me and everybody that's here, you end up breaking the system in half, which is exactly what I intend to do. And I hope everyone here will help me do by the perpetuation of this knowledge. to everyone that you know. Okay? So, not to digress, so let's continue here. One more thing about psychology that I want to say. There's 3 different ways that the attorney takes from you: meta, soma, and veta. Those are Latin terms. Okay, so meta is medicine, soma is psychology, and veta is law. Meta, soma, veta. Those are the 3 ways that the attorney takes from you. If they cannot get you in their legal process, because of course it's a process to, under the law merchant, to have their secure transactions and remain economic slaves and everything that we just read already. If they can't get you in law, they will destroy you through medicine, which is of course why everything is so bloody polluted. Everything is GMO filth. Everything is meant to pump you full of 100 pounds of refined white sugar every year, stripping out of every nutrient in our soil. Need I go on, right? I could go on for days on that. So that's the meta part. And they make money off of you because you're not self-reliant. You're not self-sufficient in being able to take care of these things in your own body for yourself. So you go to corporations to tell you what to put in your body. Well, that's never going to work out. And then if they can't get you by those 2, they eventually get you by soma. If you figure out their scheming, their lies, their system, if you figure everything out in meta and veta, the only thing they have left is soma. The only thing they have left is to call you crazy. That's it. And as a man once said, and I'm probably going to butcher this quote, and I can't even remember exactly who said it, but it was the spirit of the quote that mattered. And it was basically broken down to this: the only thing you can do to a free man, a fully, truly free man or woman, meaning mentally free, physically free, the only thing you can do to them is kill them. They will not be controlled. They will not be hoodwinked. They will not be taken advantage of. You cannot deceive them because they have the power of mind and they have the power of discernment and have learned grammar, logic, and rhetoric, which is the trivium, which we're teaching for free on the Sunday classes on the VSOF Gilded server. You cannot control someone like that. The only thing you do is kill them. And that's where we want to get to. We want to get back to an entire society of free men and women who cannot be controlled through meta, soma, or veta at all. That's the goal. That's why I created the Vocational Science of Freedom, and that's why we need to perpetuate it. And to bring in more teachers to help everyone understand the perils of these 3. Because I'm very good with the law part, but I know there's plenty of people out there that are far better at me to describe the medical and the psychology part. But so with that having said, let's continue here so we don't digress off this quote too far. So, okay, they will be stripped of their rights and given a commercial value designed to make us a profit. Okay, that's the interest. That's designed to make us a profit. That part right there, that has to do also with inflation. Inflation is an invisible tax on everyone, right? That's what they're doing, because they keep creating the credit, manifesting our credit, and never giving it back to us. But it's an exponential curve. A fiat currency system just keeps getting bigger and bigger and bigger, and it always derives its newly created money from the money that was already in existence. And of course, that can only go on for so long before it snaps, and we're pretty much seeing it snapping right now, which is what the bank bailout was about. All right. So, so that's that. So let's continue on here. After all, this is the only logical way to fund government. Oh, really? The only logical way? No, I'd say it's about the most illogical way to fund government. By floating liens, floating, there you get your maritime amnesty lingo in there. By floating liens and debts, and debt to the registrants. What's a registrant? One who registers their property, right? So they're going to float your liens and debts to you, the registrant, in the form of benefits and privileges. Well, we'll give you a benefit if you come sign this document that registers your property. The benefit is we'll then tell you what you can build on your land. The benefit is we'll then come in and tell you that we get to inspect your property. And if you didn't put your whatever in just right, as to what our statute, act, ordinance, or code says, then you get to pay a fine. In the form of benefits also means that you get to go to jail. Going to jail, these sick fucks consider to be a benefit and a privilege. Let us never forget that point. They also consider being thrown into a mental ward for, as you said, QC, recognizing actual truth as crazy. They consider that to be a benefit and a privilege. All of which you've already paid for, which I should say your estate, the credit from your estate has already paid for. So when you take a benefit of, and this is another problem that a lot of the law scholars or people that have been doing this kind of work and trying to understand the system for a long time have made a grave mistake, is that I've heard people say in lectures and talks that, oh, when you want to go into court, you want to say that you're the beneficiary. No, you never want to say that. You also never want to go into court and say that you're a trustee. If you say that, it's just over. Because if you go in and you say that you're a beneficiary, what you're doing is you're saying that I agree that you, the black-robed priest of El, sitting up there ruling for the bank, is a lawful administrator. Yeah, that's the quote, Chief. Thanks. You can't conquer a free man. The most you can do is kill him. Thank you. And the black-robed priest of El will give you a benefit of your own estate. If you take a benefit from your own estate instead of claiming the entire thing, you're literally agreeing that the administrator sitting up there is one, lawfully there as an administrator, and two, can lawfully administrate your estate, and three, maybe being the most important one, that you have not brought claim for your own estate to literally be there to claim your birthright. You literally say in court, I'm here to claim my birthright, and that would be completely correct if you had your doc set done. So, so the benefits and privileges thing, you never want to be a beneficiary from that standpoint. So just those of you who have ever heard that from any quote unquote guru, get it out of your head immediately, because there's a term that you can look up in Black's dictionary. It's called beneficium abstinente. Beneficium abstinente is a Latin term meaning that you abstain from being the heir, of taking on and being the heir. Now, they write it in Black's law as if it was some good thing from the standpoint that, well, if the heir doesn't want to take on the debts of what he's heir to, or blah, 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 that he can abstain from being the heir to not take on the debts. Well, guess what? It also means that you don't get to take on anything else either. So, never be a beneficiary. Because if you are, you automatically get into beneficium abstinente, where you're abstaining from being the heir. And of course, if you take a privilege, or if you're agreeing to a privilege, and saying, yeah, I want that privilege, when it was something, specifically, and this is pretty much always the case, when it was something lawful to do anyway, like say, for example, a house. Why do you need a permission? Why do you need to submit an application for permission to build something on your own land? Well, it's because you don't own it. It's because you're not holding that land in a allodial title. It's because you're considered to be a resident, a res, R-E-S, in debt, res in debt, resident, on land, being a merchant, and that you're not lawfully domiciled there. Because if you were lawfully domiciled, because see, people can only have one domicile. You can have many residences, but you can only have one domicile. And so people are being residents on their own land and having to pay rent for privilege, benefits and privileges, like, oh, that the fire department will come and put out your house if your house burns, or if you call the ambulance, that they'll come pick you up, right? If you're sick or if you have a problem or something, even though they then charge you again anyway. So the whole idea of this is just absolutely ludicrous. That they say, well, because you're getting these benefits and privileges, you are agreeing to this system, right? So, and that gets back to the aspect of removing yourself from all contract, which the status docs do, which I'll get into detail with later. But so to continue, this will inevitably reap us huge profits beyond our wildest expectations and leave every American a contributor that should say to this fraud. A typo there. Okay, this will inevitably reap us huge benefits beyond our wildest expectations and leave every American a contributor to this fraud, which we will call social insurance. Now, eventually they called it Social Security, but that's... Anyway, so they're telling you it's a fraud. He's telling you flat out, this whole entire fucking system is a fraud. Social Security is a fraud. Registering your children is a fraud. The whole court system is a fraud under Roman civil law. Yeah, anyway. So without realizing it, every American will insure us for any loss we may incur. And in this manner, every American will unknowingly be our servant. However, begrudgingly. Well, how convenient for them, right? That brings me to a quote that I think Goethe once said. He said, "None are more hopelessly enslaved than those who falsely believe that they are free." And in thinking about that from the standpoint of your quote-unquote typical American, I couldn't think of a more appropriate quote. None are more hopelessly enslaved than those who falsely believe that they are free. And that's exactly what we have. And that's exactly what we have to undo. Because the only way we can undo it is by the systematic teaching of this knowledge. It's the only way to get rid of this system. To get the globalists, world communists, Luciferians, secret society, deep state, all of these labels are all the same thing. Okay? Just different labels for the same bloody thing. Right? And this is the only nation left in the world that can stop them. In fact, we're the only nation ever to be created, whichever came along and said, no, we're not going along with this system at all. We don't care what you call it. We don't care if you call it feudalism. We don't care if you call it colonialism. We don't care if it doesn't matter. It's called slavery in the be-all and end-all of it. So, be gone, and we're done with you. That's what our forefathers and blood said a long time ago. And what we have to do is continue to do that. As Jefferson said, every generation pretty much needs its own revolution. And he's true. He's absolutely right. And not just a revolution from prior thinking, so that we do not hold on to ideas and systems that hold us back, but that we make sure that we always throw off any chains which are attempting to enslave us, and see the chains for what they are, and not under any circumstances say, Well, if they're chains of gold, okay, fine. I'll just be here all nice and happy and enjoy the gold chains. No. But that's what House is getting at here. I mean, the very aspect without realizing it. That is the main point. It's the ignorance that keeps everybody here. It's the ignorance that is the problem. All right. And if we get past the ignorance and we can teach people these things by simply just by no other thing, maybe just giving them this quote, because people always ask me, well, what should you give to somebody who's just starting? I say give them this quote and then let them look up every single word in it. It's not that long. It's one page, particularly in larger font size. It's only one page long. If they look up every single word and phrase in this quote, honestly, I would say that would probably wake somebody up faster than anything else that I know, which is why I use it. But of course, it's just the beginning of their journey, not the end. So, speaking of the end, to finish out the quote here, the people will become helpless and without any hope for their redemption. Now, redemption, that specific term, what is he talking about here? He's talking about the redemption of your estate. To redeem, to reclaim, to have it, to have to hold, right? To have and to hold forever. That's called the addendum clause, which you see in all land patents, right? To have and to hold forever. It's also something that used to be in most marriage vows when people took vows to each other. Yes, I agree to have and hold you forever, right? That's the addendum clause. That's what we need to do, is have and to hold forever. Well, our forever, right? Until we then have an heir and pass it on to the heir. That's what he's talking about. That the people will become helpless and without any hope for their redemption. They never wanted us to ever be able to get back to our estates, to be able to claim our redemption. That's his sick point with that quote, right? And we will employ the high office of the president of our dummy corporation to foment this plot against America. Well, if anybody ever had any question about the fact that the United States is a corporation, there's a pretty good proof for you. And if you want the rest of the proof, you can go to 28, which I'll type out here. It's 28 USC. Oops, I don't want to type it out in the document. Okay, so it's 28 USC 3002, and I believe the sub is 15. It's either A or B, but and somebody could pull that up. That'd be great. You should be able to find it pretty easy. I think it's 15A. Yeah, Blue Star, you'll know one way or the other. And what that says is that it specifically says right in U.S. Code that the definition of the United States is a corporation. It says the United States is a federal corporation. Bam, right there in your face. You have corporate government. And that was established in the District of Columbia Act after the Civil War, after Lincoln bankrupted the Republic. Anyway, I won't get into Civil War history. That'll be for another day's class. So, that having been said with this quote, you can see now, and I'll just read the whole thing straight through without any commentary, so you get the whole feel of it. Very soon, every American will be required to register their biological property in a national system designed to keep track of the people, and that will operate under the ancient system of pledging. By such methodology, we can compel people to submit to our agenda, which will affect our security as a chargeback for our fiat paper currency. Every American will be forced to register or suffer, not being allowed to work and earn a living. They will be our chattel, and we will hold the security interest over them forever by operation of the law merchant, which is the next section we'll get into. Under the scheme of secured transactions, Americans, by unknowingly or unwittingly delivering the bills of lading to us, will be rendered bankrupt and insolvent, forever to remain economic slaves through taxation, secured by their pledges. They will be stripped of their rights and given a commercial value designed to make us a profit, and they will be none the wiser, for not one man in a million could ever figure out our plans. And if, by accident, one or two would figure it out, we will have in our arsenal plausible deniability. After all, this is the only logical way to fund government, by floating liens and debt to the registrants in the form of benefits and privileges. This will inevitably reap to us huge profits beyond our wildest expectations, and leave every American a contributor to this fraud, which we will call social insurance. Without realizing it, every American will insure us for any loss we may incur, and in this manner every American will unknowingly be our servant, however begrudgingly. The people will become helpless and without any hope for their redemption, and we will employ the high office of the president of our dummy corporation to foment this plot against America. So, there you have it, as far as what the system is. I've broken it down, and I break it down much more thoroughly when I cover the Colonel Edward Mandell House quote, which you can find on the Vocational Science of Freedom YouTube page. But the main part that we'll get into now is exactly what the hell is the law merchant, and what is the operation of the law merchant, because this part right here of this quote is the single most important thing that I think everybody should learn, because it was one of the more difficult things for me to learn. I did not understand what it was. It took me years to track it down, break it down, and figure out what that term meant. So, let's move on to the next handout in the outline, which will be the law merchant. And this is pages from a book called The Pied Pipers of Babylon, which I have in the Vocational Science of Freedom Law Library, the full book. So Vocational Science of Freedom's members, VSOF members, have access to that in the law library and can download it and read it thoroughly and completely, which I would suggest everybody do. For this aspect of this, the beginning of this book, so you're under foreign law, right? So here's the law merchant, the aspect of Roman civil law. And this is just a review, so I'm just going to read some of this part, and then we'll get into the book a little bit. But just a little bit. I only pulled a few pages because, if I remember right, I think the book's 200 and some odd pages. But so the key discovery of Dr. Spear is, and that's this gentleman here, Dr. Verl K. Spear. He had a doctorate in common law back in the days when you could get such degrees. So the key discovery of Dr. Spear is that Americans have become subject to a foreign system of law, essentially a form of the Roman civil law. This jurisdiction, he says, was imposed on our country by England. I would say by the attorney. I mean, we pretty much threw off the control of England and set up our own system, but it was the attorney out of the city of London that came back in to retake us back over by the boiling the frog technique. He contrasts this with the other great system, the common law. Common law, as Spear defines it, is based on reason and the immutable laws of God and nature. Yes, it is based on natural law. It is the law of conscience, and as well, it cannot be only written about. And that's true. True law is spoken. It's always oral. It's not written. So I'm going to skip this little part down here and then get down here. Once again, today Americans are the victims of an attempt to force this foreign law on them. That's the law merchant. Whether you call it the law merchant, maritime law, or equity, slightly different versions taken by the civil law. And again, whenever you say the term civil law, it always means Roman civil law. So these systems, which a lot of people talk about, that it's all about maritime amity, that's the problem, you don't want to be maritime. Okay, well, it's not just that. It's the law merchant system connected with maritime amity law, which is kind of morphed into this bastardized thing called equity, which I'll get into exactly how equity came about later. And so again, it's slightly different versions of this idiocy. So the importance of this issue is highlighted by contrasting common law with these other forms. Under the common law, you have all your constitutional rights. But when you are aboard a ship at sea, your captain is legally a dictator. You have no rights. You only have privileges conferred by the captain. Today, says Spear, maritime law has come ashore and threatens to squeeze out all of our rights, which clearly it's already done from the standpoint that anyone who is under the system or considers themselves a citizen of the United States is done, has none, and unless they realize what is going on, they never will. So they get tricked out of their common law rights and into maritime courts, just as happened more than 200 years ago? Question mark. Spear explains in this book. Furthermore, he examines the principles applicable to the resolution of this dilemma and how they may be invoked and implemented, which is exactly what we're teaching at the Vocational Science of Freedom when it comes to the self-government quadrant, and what a lot of what the free Sunday classes are all about as well. So I'll skip the rest. It's basically an advertisement. So you are lured back into slavery by the supposed benefits the establishment would confer on you, which is exactly what was stated in the Mandel Edward House quote, such as Social Security and convenient checking accounts. Right. So, so this is Verl K. Spear, and as I said, he had a doctorate in common law, right there, Doctor of Common Law, and these are now pages taken from this book. So as you see, I'm skipping to page 74 here, so we can get into Law Merchant. So Part 4, Law Merchant. Introduction. Law Merchant is a name often used in law. I'm going to make this a little bigger for everyone. The law merchant is a name often used in law to denote the customs which have grown up among merchants in reference to mercantile documents in business, such as bills of exchange, bills of lading, etc. Remember what the Mandel Edward House quote, right? We will hold they will deliver to us the bills of lading, right? Okay, so and I'll let you look that up on your own to let you know what it is. I won't deny everyone their own right of or their own pleasure of self-learning. It is a system consisting largely of the usages of trade and applied by the courts to the contracts and dealings of persons engaged in mercantile business of any kind. In short, commerce. Blackstone classifies it as one of the if you don't know who or what Blackstone is, Blackstone's Commentaries. Blackstone's Commentaries is one of the most important law books everyone needs to read from start to finish, and it's going to be difficult for the beginner, but it'll be, think of going through Blackstone's and reading Blackstone's as being not only your beginning book, but the single most important, like your beginning and end book of all law. If you read all of Blackstone's Commentaries, got out a Bouvier's Law Dictionary, which also is for free on the Vocational Science of Freedom Law Library, and looked up every single word that you didn't know what it meant, or even that you thought you knew what it meant. Just look up every single word anyway. The easiest way to do this. And to go through Blackstone's Commentaries. When you get done going through Blackstone's Commentaries, say the third time doing that, there will be very little, if anything, you do not know about how all the various different systems of law work. And I mean all of them, because they're all covered in there. Because England had maritime admiralty courts. In fact, they were the ones that established maritime admiralty courts when the laws of Oleron were brought back from the Crusades by Eleanor. And Eleanor was the mother of both King John and King Henry the Lionheart. And of course, King John was the evil King John, the one in the Robin Hood stories that Robin Hood fought against. He was a real guy, and that was the guy who was forced to sign the Magna Carta. But his mother was the one that brought over maritime admiralty into England. So no surprise that the barons wanted to whack her son. But anyway, I digress. So anyway, back to Blackstone's. Yes, that's what you should read to make sure that you understand the full history of law, and particularly English law, the history of English law, so that you can understand what we're doing here, right? So, that is an aside. Blackstone's classifies it as one of the customs of England, and so a part of the common law, but it is not properly a custom. It is neither restricted to a single community, nor is it part of the municipal law of a single country, but it regulates commercial contracts in all civilized countries. Again, that term, even when you see the term civilized, you have a civilized country, a civilized nation, that means it's under filthy Roman civil law. That's all that word means. Never look at that word as a good word. If you're under a civilized country, you're being run by Roman civil law. It's not a good thing. Okay. So to continue, the body of mercantile usages, which compose this branch of law, having no dependence on locality, does not need to be established by witness or witnesses. Now, isn't that convenient? Oh, we don't have any witnesses anymore. You can just do whatever you want to. Okay, great. But judges are bound to take official notice of it. The principal branches of the law of merchant are the law of shipping, the law of maritime insurance, the law of sales, and law of bills and notes, which is the bills of lading thing which we spoke of earlier. The feudal law, which grew up in a time when property consisted chiefly of land upon whose alienation were laid great restrictions, that's the use and usufruct, which we'll get into later, was inadequate for the needs of mercantile classes coming into prominence. Yeah, was found inadequate for the needs of the mercantile classes coming into prominence. Oh, the poor little mercantile fools. Right? The poor little nasty law merchants. It just wasn't adequate for them. Well, yeah, the common law says no, the heir will have their estate when they come of full age, and that they will have their own estate without fine and without fee, and they will hold their title. Well, these little bastards, the mercantile classes, right, coming into prominence, these were the filthy fools that came over in 1066 with William the Conqueror, right, the Khazarian mob. What they want is to tax everything, and to tax the use of it, right? So they came up with the idea of use and usufruct, which is all Roman civil law filth, which predates this little part of English history. But that's what they're doing, right? But it's just interesting how that sometimes you'll read things like this, and how I was being snarky with it is exactly how you should read it. But I digress. The courts, when commercial contracts were brought before them, adopted from merchants the rules regulating their business dealings and made them rules of law. Many of these rules were in great contradiction to the common law. Surprise, surprise. Magna Carta contained a special provision guaranteeing to merchants, among other things, the right, quote, to buy and sell according to their ancient customs, close quote. So, honestly, if the barons would have not put that damn clause in the Magna Carta, we might have been able to get rid of the law merchant a long time ago. But unfortunately, they kept it in there. So anyway, and many later statutes were erected for their special protection. As the customs of merchants began to encroach upon the common law, there was a determined effort on the part of the lawyers to resist it. I should say attorneys, but whatever. It was attempted to make the custom of merchant a particular custom particular to a particular community and not a part of the land, the law of the land, which is the common law. It was finally decided in the reign of James I to be the part of the law of the realm. An attempt was then made to restrict the application of the law merchant to persons who were actually merchants. Well, yeah, that's where it should have been in the beginning. But anyway, the courts, after considerable variance, held that, quote, it applies to the same contracts between parties, not merchants. So let's kind of do a little recap here of everything I've just been reading. So what is the law merchant? It's the law relating to contracts and maritime amnesty, insurance, and bills of lading, and these things, the things. That's what puts you under the law merchant when you're dealing with these things, as if you were a merchant that knew what you were doing under the law merchant. That's how they see you. They go, oh, okay, you have a bonded estate. Okay, you must be a merchant. Or, oh, you're paying property tax. Okay, you must be a resident. You must be a merchant, just here temporarily, and then when you're done doing your merchant stuff, you'll go away. Instead of being a lawful American, domiciled on allodial land, on land held in allodial title, as being one of the people, and holding the sovereignty of not only your own house, but of the Republic. Yeah, that doesn't help them. Everything I just said, that's exactly the opposite of what they want to see you as. Okay? So I'm going to skip the history of negotiable instruments here. You can read that later if you want to and get into what the rest of the aspect of the law merchant is. Um, well, I'll read this one little paragraph here. Because various obstacles in the substantive and procedural law as enforced in the common law courts of England prior to 1600, the law of commercial paper developed outside the duly constituted law courts, meaning common law courts. The fair courts, meaning like we're going to the county fair. That doesn't mean fair as in fair and balanced. That means literally a merchant fair, right? The fair courts, meaning this is where the merchants they did their own courts. The fair courts of England were the custodians of the law merchant from their beginning in the 12th century until their uh, cadence near the close of the reign of Elizabeth. Sorry, I lost my place there. Overlapping this period and beginning in 1353 with the enactment of the Statute of Staples. Yeah, that's another one you can read if you want to from English law. That's where they kind of laid this down. And anyway, a lot of things happened during Edward III's reign. Maritime mammalty got fully established. The idea of an equity court and chancery court got established under Edward III, and the filthy law merchant got brought into agreement or passed, if you will, into all this. So yeah. Anyway, again, I cover this in some other classes, and maybe someday I'll do. I think I'll do a class just on English law history, just to establish all this. Even though I go over a lot of it in the timeline class. So actually, the timeline class, when I get done editing that and put that up, it pretty much covers the vast majority of English law. But so anyway, to continue, the courts of the staple, which is how you should call that, is the statute staple, took over much of the commercial law business at the time. The staple courts exercised jurisdiction over the growing body of mercantile law for 200 years. Now, notice the dates here. The enforced the common law prior to 1600, and then we've got the law merchants from their beginning in the 12th century. Okay. When did William the Conqueror come over to England? 1066. 12th century is 1100. So you get that from the standpoint that, okay, then, right when it's William the Conqueror that came over with the filthy serpent seed line and the Khazarian mob bringing Roman civil law into England is when you get this whole bullshit started. Before that, it was the Court of 100 ruling England. It was local. Yes, the king, there was a king, but they held a lodial title and they were Celtic Druidic background, not Norman filth. So anyway, so that was just I just wanted to give the history of, like, to understand that this whole problem with the law merchant has been a slow boil for hundreds and hundreds of years. This is not something that just happened here. This is not just an American problem, okay? Not at all. Trust me. The people of England, Australia, New Zealand, Canada, all the quote-unquote common law nations, they're all suffering from this exact same problem. All of them. And it's because of the history of England and the law merchant and going back to this understanding. So I'll skip the rest of this. It's just more stuff about the statute merchant. And Lex Mercatoria is something the Lex Mercatoria is something that you could read. It's also a very good book to understand the law merchant, anyway. And the other one is Benedict on Admiralty, which the lawyers and the attorneys call the Benedictine, which is what U.S. District Court judges have in their chambers, which tells them everything about maritime admiralty law. But the Lex Mercatoria is a much older book, which is kind of the start of it, if you will, and it helps you understand what the law merchant is much better than the Benedictine or Benedict on Admiralty would. So later, from the time of Henry the Eighth, that's eighth, right? 5, 6, 7, yeah. Later time of Henry VIII to Elizabeth, Lex Mercatoria jurisdiction was turned over to the Court of Admiralty, right? So, like I said, the Court of Admiralty got established in Edward III's reign. The law merchant therefore developed a maritime flavor, right? So this is the difference. See, you have different forms of law here. They're not the same thing. They are different, but they're, they kind of merged. They kind of merge and crisscross certain aspects from time to time, depending on what you're dealing with. So it developed a maritime flavor and became natural for parties concerned with mercantile law to invoke the jurisdiction of the Court of Admiralty. However, the common law courts did not view this jurisdiction expansion of the Admiralty Court over commercial matters with acquiescence, and succeeding in their opposition began to take over the law merchant around 1600. Okay, this is where you get this huge battle, this battle between common law and filthy Roman civil law in England. So when the common law lawyers, a lawyer meaning know the law, not attorney, one who takes from, to a turn, meaning something that somebody that takes from one and gives to another, that when you have the lawyers coming back over and saying, okay, we've had enough of this bullshit of all you foreign little merchants trying to take over our entire system of common law and just destroy it, which is exactly what you see happening here. It's funny how history repeats itself. They said, all right, enough of this shit, and they started to turn it around 1600. Okay. Incorporation of the law merchant into a system of common law proceeded slowly. Initially, bills of exchange were extended only to foreign merchants trading with the British, then to all merchants, and lastly to all persons, whether traders or not. So you get this going in 1600 where they're coming back around and saying, okay, no, we're going to take this back over. And then, again, one of the most important dates in all of English history is 1666. Well, I should say 1665, 66. Because in 1665, I believe it was the date of the Great Fire of London. So basically, what the Khazarian mob did, which is what they always do, because they burned Rome to the ground too when people had pretty much had enough of them, or they thought that they were, quote unquote, losing control. They just burned Rome. Of course, under the agreement of Nero, who was a psychopath, but that's usually who they make sure is in power before they do something like that. They make sure there's an absolute psychopath in power. So anyway, they burned London to the ground, and then they initiated the most current version of the Sestrique Vi Act, which basically said, if you do not come forward and prove yourself to be living in an action to reclaim your state, basically the crown keeps it. So that's interesting. So they had literally this system set up back then slightly differently than what House was explaining in the quote, but nonetheless, they were pretty much trying to get back to this scenario. They want this scenario where everybody's considered dead to the common law, everybody's under the law merchant, and they get to control everything because you don't understand how bills of exchange work and how insurance works and all this other garbage, which is just fiction. It's all fiction in the air. It's just poof. It's nothing substantive at all about it, unless you're actually talking about gold and silver. But so in 1756, Lord Banfield, Chief Justice of the King's Bench, incorporated vast additions of civil law, Roman civil law, into the system of common law and moved the action of assumpsit, which, all right, I won't get into that yet, from the action of assumpsit from law into equity, thereby denying trial by jury on writs of assistance. Arbitrary acts of mercantilism under the jurisdiction of this civil law sparked the American Revolution. Any questions? You see how the connection of what the law merchant has always been our bane. This is the problem. It's the attorney. The attorney is your mortal enemy because they perpetuate the law merchant and try to get you under it and control you by it, just as the House's quotes clearly laid out. So, arbitrary acts of mercantilism under the jurisdiction of this civil law sparked the American Revolution. That is an absolute true statement. That is why it happened. And if you throw out all the bullshit from people lying and trying to rewrite history as to why the American Revolution happened. Taxation without representation. That had nothing to do with it. It had to do with this and the fact that we could not create our own system of money, that we had to borrow everything directly from the Bank of England and instantaneously put the colonies into debt, permanent debt. And we looked around and said, what are we doing? This is ridiculous. So let's get the rest of this get down. I have some more notes down here. As I said, you guys can read this whole entire book at your leisure. So the law merchant is founded on expediency and subject to changes with the customs of merchants. Our courts are bound by constitutional clauses and treaties to take notice of these customs of merchants, and all debtor-creditor relationships are within either the jurisdiction of equity or admiralty maritime. So, all of you people out there that have any court dealings, suits, dealing with debit, credit, dealing with taxes, all that is under that jurisdiction. So how do you crush that? You get out of that jurisdiction. Or you come into that jurisdiction in your proper capacity and say, hey, hold on here. I'm the creditor. I don't know what this guy's talking about, but that's my credit. That credit comes from my estate. Tell him, Your Honor, to prove that the credit is his, not mine. Is he alleging that I borrowed his credit? Is that what he's alleging, Your Honor? No, Your Honor. It's my credit, of which he has assumed that I've abandoned, which is not true, Your Honor. I have claimed my credit, including my entire gross estate, and here's my status docs. Go fuck yourself. That's how that would play out. So, and if the subject matter and cause of action is exclusively maritime in nature, it is not a maritime admiralty claim, whether so identified or not. Now, what does that mean? Every insurance contract, I don't care what it's for, is all under maritime admiralty jurisdiction. So, why do you think they all have all these Roman civil laws if you have to have insurance on your motor vehicle? Because one, you don't own it, because the MSO, the manufacturer's certificate of origin, which, by the way, a friend of mine actually has some pictures of, because he drives cars back and forth between dealerships, and guess what? When he drives those cars back and forth in dealerships, you know what's in the glove box? The actual manufacturer's certificate of origin. And he's taken some pictures of them, and they're very interesting. And I think all of you know who that is, who is actually chiming in chat right now. So, yeah, you don't own your car. The manufacturer's certificate of origin has been transferred to the Secretary of State, Daddy, to whatever state you gave them a driver's license for. So when you're going into a dealership and you're asking, hey, I want to buy that car, so-and-so, what they do is they say, okay, give us your driver's license. And then they fax the manufacturer's certificate of origin to the Secretary of State of whoever is your daddy. And you don't get it. You have to demand that you want the manufacturer's certificate of origin, but you have to do it in a separate state. If you want the manufacturer's certificate of origin of a car, you have to, like if you lived in Wisconsin, you'd have to go over to Michigan or Illinois or Minnesota or wherever, it doesn't matter, any other state other than Wisconsin, to demand it. And then you would have to say, and then you would bring it into Wisconsin and say, I am importing this property. Sort of. I mean, in a way, you'd be importing it, but again, still, you're getting into the aspect of maritime admiralty. But the point is that they will not give it to you if you buy it in the same state of which you have a driver's license. Isn't that interesting? Because that's why they can then force you to take out insurance on it, and they can say, "Oh, we can fine and fee you if you don't have car insurance," right? Because you're using something that's not yours. So then that's the aspect of the benefits and privileges, right, of going to jail part. Yeah. Anyway. So to continue, the Supreme rule of this law merchant is, he who trades with a merchant becomes a merchant for the purposes of that transaction. That is extremely important. That's how everybody gets caught. So Further, it makes any debtor liable on a summary judgment to any merchant who may bring a charge of default. So you want to stay out of that situation? You have to come in and make a claim to say, hey, hold on. I'm not the debtor here. I'm the creditor. I don't know who this idiot thinks he is, but that's my credit. It's not his credit, it's my credit. Which is, of course, the aspects of how the IRS has this all set out and laid out in 1099 OIDs. When you file a 1099 OID original discount, you're telling the IRS, yeah, I've created this credit. These are the guys that have the credit over there, and at the end of the year, I want it back. And then the IRS goes after them instead of you. That's how this is all supposed to play out. As far as those that wish to, quote unquote, play the redemption game, I don't get into that, nor do I. I mean, even though I know quite a bit about it, I've never felt that's never been the solution. So I mean, if people want to play that game, and you think you can do it, fine, great, no problem. You can work that magic if you want. It's not something that I'm ever going to bother with because it perpetuates the problem of the system itself. And besides, once you claim your whole entire estate, you claim all the credit anyway. So there's no reason to, quote unquote, come back in. Okay, so further, it makes any debtor liable to summary judgment on a merchant who may bring charge of default. So yeah, this is what you get a lot of times in these maritime admiralty courts is they'll say, oh, well, they issue out the suit, they default you with notices pretense, so they'll send out 3 notices, and you don't respond to the notices. Basically, they file it into the court as a default judgment because they took care under the law merchant system. Maritime admiralty, you do what's called your administrative process, or basically what's the law merchant process system, outside of court. It's the 3 knock rule. You give somebody 3 notices and then a default, and then you just take the 3 notices and the default, and which is usually done by notary, or can be done by notary, I suppose, or attorney, whatever. And you take that into the court, and if they haven't responded, you get a default judgment. That's usually how all these credit card things and whatever debt stuff usually works, right? But if you go in there and you say, hey, wait a second, I'm the sole lawful heir and executor of that estate, and you say it specifically, you serve it onto the corporation, which is pretending that they're the creditor, and you get your process service affidavit back from the process server saying, yes, this is what you served them. You served them a status doc set, yada, yada, yada. Then you take that and you file all that into the court case, and I would also serve the judge personally in chambers, and say, look, this whole entire case is an administration of my estate. I'm the sole lawful heir and executor. I don't know what the fuck any of you guys are doing. And you better explain it, because if not, you're going to have a $300 million liability on your hands. Because if you administer my estate, you will have agreed to be trustee. And if you agree to be trustee, you have to put up a $300 million bond for potential fiduciary malfeasance. And the vast majority of these people do not want liability over their heads. So that's that. So, and then he gets into Article 1 versus Article 3 courts, which I won't get into, but this is basically the difference between the law merchant courts and the aspect of equity and how it ends up under Roman civil law, so on and so forth. Again, you can get into all that and read the book. I think I might have a few more notes down here, maybe not. I think we might be done with this one of what I wanted to cover. But as you can see, the Pied Pipers of Babylon book is a pretty good book. It explains how all of this works, what's a foreign state, how other parties are, so on and so forth, the judicial power of law and equity and the differences of it, and the controversies. So he lays stuff out very clearly. It's one of the best books I've found for explaining the differences of these things. But so we'll leave Pied Pipers for here. Like I said, the entire book will be up on the Vocational Science of Freedom Law Library. So next handout we have is the usufructuary's obligation to preserve property. This I'm not going to be going over as extensively as that book, but we can. I do want to make sure that everybody takes a look at it. This is the understanding of. I wanted people to understand the aspect of what a usufructuary is, and this idea of use under Roman civil law, and what they're talking about. So this is a Louisiana law review. So not to be confusing here, but that Louisiana law is different. Louisiana is the one state that has kind of a different form of law because it was a Napoleonic law state before we bought it from Napoleon. Um, and it still retains a lot of that. So some of this stuff is kind of specific to Louisiana, but it's the spirit in here about the understanding that I'm going to explain in here about usufruct, and that aspect of trust relationship, trusting and pledging, which is what goes back to the house quote. All right. So anyway, this is Louisiana Law Review, 1962, and on usufructuary's obligation to preserve the property. Now, this is meaning that the one who, whoops, it's a little too big, the one who uses the property has an obligation to preserve it. Now, why is that important? It's because you do not own your own body. When you decide to put a dangerous drug into your body, I don't know, like say marijuana or alcohol, whatever, anything you want to put into your body, psilocybin, right? DMT, right, to expand your mind. Well, guess what? They look at it and say, you're destroying the property. You're not using the property in the same way that we say you can use the property. And so therefore you get a fine and you get a fee because you're not using the property, which isn't yours, in the way that we want you to use it. So now do you understand where all drug laws come from? That's it. That's where they come from. It's the aspect of you using property that does not belong to you and your usufructuary's obligation to preserve the property. They see it as a destruction of the property. Oh, your productive value goes down, or isn't. You might wake up and decide not to be a wage slave and a debt slave anymore. Well, that's not conducive to the law merchant, now is it? So anyway, let's get into this. Perhaps in the eyes of many, the institution of usufruct is a tottering relic of the Roman law past, which serves only to fetter full enjoyment of property and to clutter the law of Louisiana with uncertainty. Well, it certainly does that. Nevertheless, the institution of usufruct is very much a part of Louisiana law and a very much part of every other part of law, of the law merchant. By operation of law, the surviving spouse enjoys usufruct over the decedent's half of the community where he has died intestate. That means without a will, by the way. And this is another big situation, since we just came up with intestate here. This is another big problem, major problem. No one has a will. It is your will that they steal. And I don't mean just from the standpoint of what you write down so that you can pass it on to your heirs. I'm talking about literally your will. What you wish to do with your existence. How you wish to write your own life script. But whether you decide to walk north or south on the road today. That aspect of will. They have stolen your will from the presumption of you being an infant. Okay? And so the aspect of dying intestate is dying. To die intestate is without a will. Okay, that means that you didn't leave anything as to what your orders were, as to what you wanted to have done with your property when you passed. Right. So community where has died intestate, parents are entitled to usufruct of the minor's estate in certain instances. Moreover, recent interpretations of the Louisiana Trust Estate Act serve to warn the cautious attorney that income interest placed in trust must be in the form of usufruct, lest the transfer be voidable as prohibited substitution. So in this, the basic civilian, again, this is Roman civil law, the basic civilian theory that full enjoyment of property involves three principal rights. This is the totality of the aspect of Roman civil law when it comes to property. Okay, just that's why I wanted everybody to read this. Usus, the right to utilize the thing for one's own purposes. Fructus, or fructus, the right to gather the fruits of a thing. Gather and use the fruits of a thing. So you have land. Literally, think about it literally as fruit. So literally, you're a usufructuary to the land, so you can use the land, and it has some fruit trees on it, you're allowed to pick the fruit, right, and eat the fruit. And abusus, or abusus, the right to alienate or to sell or mortgage, right? That's your aspect of total real title here. So what Roman civil law does is it splits the title into legal title and equitable title. Well, actually, there's kind of three here because there's this other fruit thing, but usually it's just equitable title and legal title. Now, equitable title is the aspect of the use part, or the ability to gather the fruit part. That means the equitable title is what you can use. You can use the thing, but you don't own it. And then Roman civil law considers the term legal title. Go again, legal, that's not lawful. The difference between a whole different system, Roman civil law compared to common law. So under common law, you have lawful. Roman civil law, you have legal. So you have legal title under Roman civil law, which is the right to alienate, sell, or mortgage. So the usufructuary, which is the one who uses the thing, enjoys the first two of these rights. Right? Notice that, but not the third one. The Civil Code defines usufruct as the right of enjoying a thing, the ownership of which is vested in another. You get to use all this stuff, but you don't own it. And therein lies the major problem, right? So the usufructuary may draw from the thing its profits, its utility, and its advantages. If the thing can be enjoyed without changing its substance, the usufruct is perfect. Now, what did I say earlier about drug laws, right? If you're changing the substance literally of your own mind and waking your own mind up, they see that as something you're not allowed to do. So, if, however, the thing cannot be used or enjoyed except by consuming it, the usufruct is imperfect. The obligation of the usufructuary, you, the one who's using the thing, having imperfect usufruct of a thing is simply to restore its estimated value at the termination of usufruct, meaning the time of which you can no longer use it. And what does that represent? Or how does that get represented in our understanding of this system? The termination of usufruct, that's your death certificate. That's the termination of the usufruct, right? So on the other hand, while usufruct is perfect, the usufructuary must return the thing itself in its original condition except for normal wear and tear and deterioration which have not been caused by his negligence, so on and so forth. So that's the aspect of that. I'm going to read a few more things in here. I'm not going to read all of this again. Since usufruct was not a form of ownership, it could not be created by the usual modes of conveyance, meaning the usual modes of conveyance. That would be livery of season. When you talk about modes of conveyance, of how to convey things, like when it specifically deals with land, the mode of conveyance was called livery of season. So not by traditio, since it was not physical, but an incorporeal right. All this stuff is incorporeal, right? It's pie in the sky, trust bullshit, right? Nor by mancipatico, since it was not a res Municipisi? Not sure how to pronounce that. Whether the usufructuary's obligation to preserve the thing subject to usufruct was created by stipulation at the insistence of the praetor. That's the praetor is the ones in Roman civil law who were basically like the judges, or existed at civil law and was merely enforced by him. It is clear that the standard of care to which the usufructuary was held was that of a prudent paterfamilias. Interesting that we get this term paterfamilias. What is a paterfamilias? A paterfamilias is the one who rules the house, the male, specifically the male that rules the house. That's your paterfamilias. The female side of that is materfamilias, right? So, a prudent paterfamilias, the praetor requiring security for adherence to that standard. So even back in Roman civil law, and this is literally going all the way back to Rome because we're talking about praetors here. This is a Roman thing. So literally, you're going all the way back to Rome. This is how it worked back then too, right? The praetor requiring security for adherence to that standard. You have to give security to tell them that you're going to use the thing the way that the Romans wanted you to use it, or that the Roman civil law told you to use it. Now, what is that again? That's exactly what we have in the standpoint of car insurance. You're going to get out car insurance, and you're going to use the car exactly the way I tell you to use the car. Right? You're only going to travel on this side of the road. You're only going to travel this fast. You're only going to, right? You can't have too loud of a muffler. You can't have shiny lights on it that look like, oh, I don't know, land pirates. All these things, right? That's the aspect of requiring security for adherence to that standard. Whatever the standard of Roman civil law says, you have to do. Okay. So let's skip down here a little bit. As nearly as can be determined, the obligation of a prudent administrator or paterfamilias is analogous to that of the uh, compensated bailee or reasonable man at common law. Okay, so the compensated bailee is the one that has the one who has actual consideration, who's given actual consideration to take care of something, or reasonable man at common law. So those are the differences, right? So you see this entire difference between Roman civil law and common law, and the difference in the terms, right? Now, the only reason we use paterfamilias in our paperwork, even though it's an aspect of an ancient Roman word, is that so that they understand that we are this, but it literally means this at common law. Um, and this just depends how much you want to browbeat them. I like to use the word paterfamilias and materfamilias because I know it means this. I know it means a reasonable man at common law. So you could also put, if you wanted to, under your paperwork, but it's not a necessity to do so. I mean, it's not even a necessity to put paterfamilias underneath if you don't want to. But um, you could put reasonable man underneath your signature line. You know, so John Henry House of Doe, reasonable man, which would look kind of funny under a signature line. But of course, some people might think that the term paterfamilias might look funny under the signature line unless they knew what it meant. So that's just a little aspect of some of the signature lines on the status docs. So the obligation to not alter destination of the property. The Louisiana Civil Code provides that during the usufruct, the property must not be altered in form, distribution, or destination, or improved without the consent of the naked owner. This provision has its roots in Roman civil law. That's the aspect of what they're doing. They're considering themselves the naked owner, even though technically you are. But I would never get into arguing Roman civil law terms. I just say I'm the heir. I'm the heir and the executor. Because there is an enormous difference between the term executor and the term administrator, which I'm not sure I have in the handout folder. But when we break for lunch here in 15 minutes, um, what I'll do is I'll make sure that I put the definition from Bouvier's Law Dictionary of both executor and administrator, and we'll go over that because it's really important to understand the two of them, because this is again the difference between Roman civil law, which is the term administrator, um, and the term executor, which is basically unknown at Roman civil law. So the Justinian legislation provided that the usufructuary might enjoy the subject of the usufruct only in the manner his grantor had been in the habit of enjoying it. Now, that's another term, the grantor. The grantor has all the power in any trust relationship and in any aspect of the estate. So, again, this is another term that we use in the status doc set. You are the grantor, heir, sole lawfully appointed absolute executor, your paterfamilias if you're male, materfamilias if you're female, one of the people, an American, you've come of full age, you've been found to be living, obviously, and you're competent to handle your own affairs. These are the critical terms and definitions in law, which you need to stand on to eradicate anything that is opposite to what I just stated. And that's what we do in the doc set. And it's what you should do in every court case as well. If you ever get into a situation where you got to file something into a Roman civil law court, or you want to counterclaim them and file suit in a common law court. Either way, you're going to want to make sure that these facts are stated and laid out clearly on the court record. So, So anyway, so that in his manner, the grantor may in the habit of enjoying it. So whenever the grantor gives something to the usufructuary to use or whatever, under Roman civil law, it was said that you could only use it in the same way that the grantor had used it. So this is where you get into, and I'll get down here. I think I've got a note in here actually about, um, yeah. So I'll get down here. This is getting into the use of the land. So in Anglo-American law, the legal life tenant whose duties with respect to non-alteration of use are similar to those of a usufructuary. It may not change the premises in such a way that remainder men or revisioners would have reasonable grounds for objection thereto. This is where you get into the county under Roman civil law determining the different types of land. Is it residential? Is it commercial? Is it industrial? Is it agricultural? Right? This is where you get this from. That because they've determined that these are the uses, the uses that you can use the land for, and in the same way that the last one did it. And this is what was getting back into this up here, that the Justinian legislation provided that the usufructuary might enjoy the subject of the usufruct only in the manner his grantor had been in the habit of enjoying it. So when you come along and you purchase land that's registered, right, as commercial, you can't tear the building down and make it into a cornfield. Where the fuck do you think that comes from? It comes from this. It comes from this Roman civil law filth. This idea that you can't do what you want to with your own land? Ridiculous. And that you have to do what the last person did because it was registered that way? Again, ridiculous. The whole entire system of land registry is Roman civil law from the standpoint of the Torrens registry system and how this is being used against us. Okay. And the more I'll get then this gets more detailed. The restatement of property indicates that it is objectionable to alter, erect, or remove a building to change the configuration of the surface or to devote the use of land to a purpose substantially different, which is what I just said. If you bought agricultural land, can you come in there and decide to put up a shop or decide to come in there and put up an industry, right? Make it industrial? Nope. Not without daddy's permission, you can't. So, interesting. CLF3 just said the prick that invented property zoning in the 1920s was from here. He's talking about where he, and I won't say where he lives, but unless he wants to. Um, that's funny. Yeah, so that's the idea of zoning. It comes from this aspect of use and usufruct, right? So just know that. Know that where we get these things, this idea of zoning and this different aspect of use. This is Roman civil law. This is the use and usufruct of that, right? So, for instance, it is objectionable to remodel a residence for the use as a store, which is exactly what I said. So, you can't turn a residence. You can't run a business out of your house. What? What do you think every single, well, not every single, but practically every single colonial family did? The bottom floor was their storefront, or was their office, or was their business, and they lived upstairs. You still see a lot of this in some buildings in America where you can still find these two level structured. Um, and okay, there you go. Oneida County zoning ordinance. Yep, and the original. That's where it started from. And yeah, and now you have it in the Torrens. You have it goes with the Torrens registry system. The zoning aspect is just what I was just describing, and that if you're the usufructuary and you're sitting there using the land, but you do not have a lodial title to it, you can only use it the way they allow you to use it. Meaning you can't turn your residence into a store, right? To construct a new building to be used as a garage, to construct a golf course upon farmland, and to clear timber for cultivation, right? Oh, you can't do any of that without permission. No, 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 no. Really? Yeah. If you had a lodial title to your land, they come on your land, you shoot them in the face. Period. That's what a lodial title means. It means no higher land lord. And then in the original Wisconsin Constitution, it specifically states that all lands in Wisconsin are allodial and feudal tenures are prohibited. That's in the Wisconsin Constitution, my good people. So what does that mean? It means that if one of the people has a right in one state, guess what? You can claim the same right in any other state because that's the equal footing clause. If you have the right to do something in one state, you have the right to do it in another. And I don't care what the communists say. I don't care what the federal overlay says. It doesn't matter. Yes, you can claim a allodial title to your land. We have a whole process for it, which is separate than the status doc set because, of course, we don't give out the process for the declaration of allodial lands for those who obviously do not have or cannot claim actual ownership to land anyway. Somebody that rents isn't going to do that. But it is, yeah, it's a fun process, as Tobias said, Spectre said, from the standpoint that you get the land patent. You get to look up the original land patent for the land, the portion that your land is, and usually it's not the entire land patent. Now I will say that there are land patents that I've seen, which are literally for single lots, original land patents for single lots in newly formed cities and towns. And actually, one of my friends has one, so it was really interesting to look at that one. But usually they were in 160 acre sections for the westward expansion, and then they got quote unquote subdivided and into smaller plots and smaller plots and so on and so forth. But the process of the declaration of allodial lands, which I'll probably do an entire class on land and just to go over that process of what that is. But in short, here, just to cover it, the Declaration of Allodial Lands was written by CLF3 and a gentleman who's now passed on, who was one of our mentors, Steve Carr from Wisconsin. And what we did was we were going into, this was back during the foreclosure crisis, and we were going back into courthouses and finding out who got foreclosed on. And then we'd go to the people that got foreclosed on. I would say, hey, you got foreclosed on. Do you want to sell us your land for $21 of silver? Most of them would be like, yeah, sure. I mean, I don't, I'm not going to fight it, yada yada. And I'm already out of there, or whatever. And so they'd sign a contract for 21 ounces. Then we'd take the bill of sale for the land, go down and put it into the county recorder's office as a lawful bill of sale for the land. Then we'd do the declaration of allodial lands on the land, and then we'd tell the bank to get their house the fuck off our land. And it drove everybody nuts. It drove all the attorneys crazy in Wisconsin. And we were doing it so much that we eventually got to the point where the governor of Wisconsin, and I can't remember who it was at the time, but the governor of Wisconsin actually called Steve Carr and asked him, actually begged him to stop doing what he was doing. And he was basically like, go fuck yourself. With his interesting Australian accent, he told me one time what he said to him. He said, do you know that what you're doing is fraud? Do you know that you're having filthy feudal tenures in the lands of Wisconsin? Him saying this to the governor is just funny. But eventually what they did was they came in unlawfully. They just basically hired judges that were paid off. The banks hired judges that were paid off, and what they did was they filed writs of assistance that weren't backed by any court case to kick us off the land. They were literally just trying to come in and take the property out of the house and whatever else. But the trick is that technically they couldn't ever cross that. As soon as they were to cross onto the land, they'd technically be trespassing. So they couldn't get from the land to the house. But yeah, anyway. But not to say, because the process is completely lawful. But now we have a process to be able to stand on it, as long as you're doing it prior to getting yourself into any problem situation as far as property tax deeds or mortgage foreclosure or whatever else. You want to be in front of all of that. Not to say that you can't undo it if it does come upon you, but it is much more difficult, as some people on here will attest to, than to get it done and get it out of the way prior to. Because, as the saying goes, when did Noah build the ark? Before the flood. So I'll just finish up this last little part, and then we can break for lunch. So anyway, the common law courts have sought to limit the objections of the owners of future interests by requiring that they be quote unquote reasonable, and that the life tenant be shown to have used the property contrary to quote unquote good husbandry. Now that's good husbandry is also a common law term. That's where we get the term husband from. Apparently, if the legal life tenant can justify his changes and improvements on the basis of acknowledged good business or farming practices, so long as he has not altered the general economic purpose of the land, he is not held to have intruded upon the interest of the revisioner or remainder man. The revisioner or the remainder man. That's the third aspect of that third part of what we covered way up here, or was it right here? That's the last thing. This ab us is the right to alienate or sell a mortgage. That's the one. That's the remainder man. He's the one that actually has the right to sell and do any of that stuff, right? So that's what that. I just want to reiterate and come back to that term to make sure that you guys knew what that meant. Taxes and charges. The Civil Code provides that Louisiana usufructuary is liable for all annual charges, taxes, ground rents, and regular charges imposed upon the thing subject to usufruct. Thank you and have a nice day. Any questions? Because that's why that's your property tax, folks. That's it right there. That's how they do it because you don't own it. And I think that was my last. Nope, I got another note down here. Okay, conclusions. From the foregoing, it should be amply clear that without specification in a testament, again, that's a testament, or trust instrument, which is what we're not doing, but we're doing a testament. That's what the status docs are. They are a testament. When you put down your testament, the status docs are a testament of your will. They're a testament of what you're claiming whilst being alive, of course, having been found to be living. So whilst you're living, you lay down your testament, you lay down your will, and that's the specification in a testament. So that's what you're doing. You're being amply clear of what your specifications are to the use, who owns, and the rights to your estate. That essentially is everything that what the status docs do. I mean, they also do a lot of other things like rebut presumptions and so on and so forth. But the main reason why we're doing it is for that reason, to give specification and be specific in our testament as to who we are, what we are, how we want our lands to be controlled, used, right? Say, or trust instruments. Okay, so to continue, or trust instruments, the obligations of the usufructuary to preserve the thing are most uncertain and may bind him undesirably, right? So if you're not certain about what you're doing, you're not certain about laying down what your will is, or where the line in the sand is, they'll determine for you whatever the hell they're going to determine for you, and like it says, may bind him undesirably. Yeah, you think? It is suggested that the situation might be considerably improved by adopting a clear distinction between ordinary and extraordinary repairs, and by permitting more flexibility in the way of usufructuary may use the property. Blah blah blah. That's all Roman civil law bullshit. For how else can we control them? So, yeah, so that being the last note. So that's an aspect of the law merchant, and we'll continue with the law merchant documents when we come back from lunch. And the next one we will get into will be from Stives to Cyberspace, the law merchant. So this will be a document that will cover basically the more recent history of the fact that this is written fairly recently, 2006, and it's not that far back. But meaning the point is that they're still writing about the law merchant and the understanding of it because they have to, because most attorneys don't even understand why it's important and what it's doing. So with that, I'll start back up about 1 o'clock, 1:10. So we'll take a break down, then we'll come back to this when we get back.